Let us start with the Indian Contract Act 1872. So, what is an Indian Contract Act? Before understanding the chapters, it is important to understand the Indian Contract Act. The Indian Contract Act is passed in 1872 on 1st September and it applies to all the contracts in the India. When one person signifies to another his willingness for to obtain the assent of such person to such act or abstinence, he is said to make an offer. For example, I am offering you to buy this highlighter. Here what I am making is an offer. And when you accept to buy my highlighter, it becomes a promise. And when we both have considerations in such promise, for example, that A agrees to buy B's watch for 10,000. Here, the watch is consideration on the part of B and the money is consideration on the part of A. So when it involves consideration and the both have consideration, which also means exchange for exchange, it becomes an agreement, and when an agreement is legally enforceable, it becomes a contract. So all the contracts in India are governed under this act, under the Indian Contract Act 1872. So it governs laws relating to the contracts in India. It was passed by British India, and as discussed, this act is applicable to whole of India, including Jammu and Kashmir. Let us understand some key terms before going to the chapters, so it makes your concept easier and it becomes easy for you to understand. Section 2 Clause A of the Indian Contract Act defines what a proposal is. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal or an offer. For example, if I offer you to buy this pen, here what I am doing? I am communicating to you my willingness so that when I make you an offer, you accept it. Here, the communication of willingness is very important to make it a proposal. I must have communicated you what I want to sell or what I want to what I want you to purchase. Section 2 clause B defines promise. When the person to whom the proposal is made signifies his assent, the proposal is said to be accepted. For example, I offered you to buy this pen, and when you agree to buy this pen, you accept my offer, you accept my proposal, and it would be said to accept it. And when you accept to buy my pen, it will become a promise. The person making the proposal is called the promiser, and person accepting the proposal is called the promisee. I am asking you to buy my pen. I am in this example, I am the promiser, and the person accepting the proposal is called the promisee. And you agree to buy my pen, you are the promisee. Now let us understand what is consideration. When at the desire of the promiser, the promisee or any other person had done or abstained from doing something, or does or abstain from doing, or promises to do or abstain from doing something, such act or abstinence or promise is called a consideration for the promise. Basically, an exchange for exchange. I offered you to buy this pen for 10,000. So the consideration on my part is this pen, and the consideration on your part will be the amount paid for the pen. And the agreements which are without the consideration, they are void, which is governed under section 25, which we will understand further. However, there are 2 or 3 exceptions. Basically, one of its time barred debt, and we will cover these topics in the further lessons. And now let us understand what an agreement is. Every promise and every set of promise forming the consideration for each other is an agreement. In simple words, an offer plus acceptance is an agreement. So we discussed this as when an offer becomes accepted, it becomes a promise, and when promise has a consideration, it becomes an agreement. Reciprocal promises. Promises which form the consideration or the part of consideration for each other are called reciprocal promises. It requires both the parties to the agreement to do something. Now, in this above example, I offered you to buy my watch and you promised to give me money. In both the cases, we see, for example, if I say you that I will pay you 10,000 if you look after my dog. Here, both the parties are making promises to each other. So the promises, the agreement that we are making on the promises, it is forming the consideration for the promise. So the promise is from the consideration for each other. I am asking you to look after my dog, for which I am paying you 10,000. Here we both are in the reciprocal promises. An agreement not enforceable by law is a void agreement. We will understand in the further lessons what a void agreement is. A void agreement can be like agreement in restraint of marriage, agreement in restraint of trade, in restraint of marriage, keeping minors as an exception. For example, if I am saying someone to not marry someone, that will be an void agreement. What is a contract? An agreement enforceable by law is called a contract. We understood what a contract is. And an agreement which is enforceable by law at the option of one or more parties. The other party, not at the option of other parties, is a voidable contract. The contract will be void if the party having assent is valid. In this example, an agreement which is enforceable by law at the option of one or more parties but not at the option of others is called a voidable contract. And for example, there are two parties. Voidable contract is such contract on which the option of rescinding the contract is only at the option of one party. For example, we will cover free consent. Free consent cover topics such as fraud, misrepresentation. अगर मैंने आपके साथ फ्रॉड किया या फ्रॉड इज बेसिकली एक्टिव कंसीलमेंट ऑफ फैक्ट्स, अगर मैंने आपके साथ फ्रॉड किया और आप उस फ्रॉड को, मुझे बस ये प्रूफ करना होगा कि मैंने आपके साथ फ्रॉड किया है। अगर मैंने उस फ्रॉड से आपका कंसेंट लिया, जैसे मैंने आपको ये कहा कि